Hello, great people. Welcome back to Global Happenings. Today, as Nigerians are with the 23rd day of October 2023 to hear how PDP will defend their appeal against the victory of Bola Ahmed Tinubu. Right now, the bone of contention is actually the fresh evidence which was gotten from the Chicago State University, and that evidence will be what will seal everything against the current president. And there is a serious tussle right now revolving around it, as at one side Atiku Abubakar is making strong demands on the Supreme Court to accept his fresh evidence, while Bola Ahmed Tinubu says no way, the fresh evidence cannot be brought in. Each of them have rolled out the reasons why they do not want they roll out their evidence about the fresh evidence. But Atiku Abubakar had to reiterate it again, and you're going to see some of the very strong reasons that he has given why the Supreme Court have to accept his own fresh evidence. Let's listen to full details of this news. The parties are agreed that the Constitution is the fan et origo and the ground norm and supersedes any other legislation. Besides, Atiku maintained that while tribunals were established to deal with election matter from House of Assembly, National Assembly and governorship election, the Constitution gave the jurisdiction to entertain dispute from presidential election only to the Court of Appeal. Thereafter, the Constitution was intentional and deliberate in setting the 180 days limit only for election tribunal and not for the Court of Appeal. On the other hand, when it comes to appeals, the Constitution clearly and expressly extended same to the Court of Appeal. The Constitution clearly excluded Court of Appeal in the preceding subsection. Atiku further argued that based on Section 285 of the 1999 Constitution as amended, the Presidential Election Petition Court (PEPC) that heard and dismissed his petition was not an election tribunal. He contended that the framers of the Constitution limited the application of the 180 days specifically to election tribunal by virtue of Section 285(6), excluding the Court of Appeal. According to him, he said, on the other hand, when it comes to the next subsection, namely Section 285, subsection 7, they intentionally included and mentioned Court of Appeal. The tried maxim, my lords, is expressio unus es exclusio alterus, meaning that the express mention of one thing in a statutory provision automatically excludes any other which otherwise would have been included by implication. Furthermore, when granting jurisdiction to the Court of Appeal to entertain presidential election petition, the Constitution did not pretend that it was conferring the jurisdiction on a tribunal. It clearly gave the jurisdiction to the Court of Appeal, thus Section 239, subsection 1 of the Constitution specifically provides thus that subject to the provision of this Constitution, the Court of Appeal shall, to the exclusion of any other court of law in Nigeria, have original jurisdiction to hear and determine any question as to whether any person has been validly elected to the office of president or vice president under this Constitution. Which also noted that when conferring on the Supreme Court the jurisdiction to entertain appeal arising from decision in presidential election petitions, the Constitution limited itself to Court of Appeal and made no mention of tribunal. He cited Section 233, subsection 1 and 2e of the Constitution, which provides that the Supreme Court shall have jurisdiction to the exclusion of any other court of law in Nigeria to hear and determine appeals from the Court of Appeal. An appeal shall lie from decision of the Court of Appeal to the Supreme Court as of right in the following cases: decision on any question whether any person has been validly elected to the office of president or vice president under this constitution. He added that it was based on the above fact that the Presidential Election Petition Tribunal Court itself administratively refused to be referred as the Presidential Election Petition Tribunal, but the Presidential Election Petition Court. The case is not whether second respondent attended Chicago State University, but whether he presented a forged document to the INEC that at trial a National Youth Service Corps NYSC certificate with serial number 173807 presented by the second respondent to the first respondent was equally tendered by the appellant stroke applicant at the tribunal as exhibit BBD1A with the name Tinubu Bola Adekunle, which is annexed herewith as exhibit J. Atiku added. The issues here are very serious, and guess what? These have been the contending issues right now. Most Nigerians believe that there's no need to go to the court, that the court will not accept the fresh evidence brought in by Atiku Abubakar. And interestingly, the chairman of the Supreme Court panel, from what I have heard, what we heard is that he may be retiring on the 27th of October. So from what we are seeing, the judgment may likely come out between Monday, which is 23rd, but I know that before it gets to 27, I think the final judgment will come out. I'm still wondering how the whole thing will go in favor of Atiku, and though he had pointed out reasons why it should go, they should accept the fresh evidence, which is, if they accept it, it's point blank, the president will be kicked out of office. I don't see them accepting that, because unfortunately, the antecedent of the legal system in Nigeria, there had never been a case where, the president is being kicked out of office. I've never seen it since I was born till now. So I don't think that that will be possible. But however, it's important that the person of Atiku Abubakar do his best by ensuring that everything is before Nigerians, so that it will leave Nigerians with the opportunity to judge if the judiciary is still what Nigerians believe it should be. Fingers are all crossed, waiting for 23rd. But I'm so set. I would say I'm a bit sure that before the 27th, when the chairman will be retiring, I think that everything must have been settled by that time, or except maybe there's a new way of handling it. And the possibility of Atiku winning, for me, is very slim. I'd like to leave it there. Let's meet in our comment section and talk more on this. What's your position as it has to do with the sitting which will take place from the 23rd? Well, Atiku Abubakar will have an opportunity to defend reasons why he's fresh.